Our newly established executive education program addresses practical legal aspects that underpin the European commercial ecosystems. It really brings together two great academic institutions that have an outstanding reputation in commercial law on various levels: policy, law, and practice.
Campus Brussels of Maastricht University is ideally located here at the heart of Europe. It allows people to be easily here. We work in small groups. This building is very well suited to do so. 20 to 30 people discuss with each other examples from daily practice, and our teachers are experts for several years already in their respective fields. They work as practitioners, as senior legal consultants, members of the judiciary, or they advise companies, law firms, and government entities.
The uniqueness of our program is really that it aims to provide participants with a comprehensive insight into a pertinent, practice-driven aspects of selected commercial legal areas.
Our cooperation will offer various courses in the area of commercial law and practice, such as trade secrets, the transfer of technology, commercial aspects of intellectual property law, taxation, fintech, or energy law, to just name a few. We try to respond to societal needs and to market demands, and we look forward to welcoming them here in Campus Brussels.
The cooperation between Maastricht University and Queen Mary University of London means that we can provide a wonderful proposition covering 5 jurisdictions for this course on the protection of trade secrets, as well as input from industry.
Trade secrets are a little bit like toothpaste. Once it's out of the tube, you can't easily get it back. So our job is to try and persuade people in our target audience that that's one good way of thinking about it, to solve the problem before it starts by way of some simple steps, perhaps not so simple, but those will be core to the program that we're designing at the moment.
First part of the program, if you will, is about what do you need to do to preserve your trade secret. After the fact, you need to decide where will we litigate, where do we want to be in court. You don't always have the option to choose which court to take or which country to sue them, but these options will be there, and then it's very good that you realize what the pros and cons are of the various jurisdictions. So the perspective of the course is basically that we cover the European situation, and you have 2 levels. You have the harmonized level under the directive, and you have the national law issues. And we will focus on both. And the other angle we take is that first of all, you need to know the theory, so to say, but more important than that, in this area of the law in particular, is what do you need to do to make this happen? So what do you need to do in terms of best practices to make this work?
The in-house attorney, the external lawyers, and the in-house security professionals will all benefit from this. Because, like it or not, in one way or another, they're the custodians of trade secrets.
People in industry often face cross-border issues, and the teachers in this course, they come from the United Kingdom, from France, from Germany and the Netherlands, and also a lawyer qualified for the United States. And so we are able to cover quite a number of jurisdictions. But the issue remains primarily an issue of national tort law and national procedural law. And so there are immense differences, despite the harmonization, that remain, and which we would intend to cover during the course.